Hey everyone, so just really quickly, just to go over what I heard, which was really hard from the hearing today. There was over half an hour worth of audio problems, so we couldn't actually hear anything for all of that time. And then when we did hear, we could hear people talking. It wasn't the best sound quality. And I am registered deaf. Just I had my hearing aids on at the highest volume. I still couldn't make out absolutely everything, but I was talking to Lauren and to Cassidy at the same time. So we were, I was clarifying things with them. Did I hear that? Did he say that? And they were both amazing and did help me out with what they could hear. So we obviously missed the start of the hearing because there was audio issues. They did go over some of it. So Lively was prepared to agree to the schedule for summary judgment, her proposed schedule for amendment to the schedule for summary judgment in her reply brief. However, she filed that reply brief, I think it was like 20 minutes, half an hour before the hearing, so I did not read that before the hearing. I have since read it and I've done a separate video on it. The judge asked Wayfarer, why shouldn't Lively be allowed to amend her claims with new evidence? Wayfarer said that arguments such as the FIHA argument, that's based on extraterritoriality arguments. Lively cannot overcome that. She can't, she has stated vigorously in her second amended complaint that she is a resident of New York. The film was shot in New York, and the torturous acts occurred in New York. So there is nothing that she can say that would suddenly make her a California resident who, and the film was shot in California, and the harm she felt was in California. There's nothing that she can add to that, and that's fair. They also said the retaliation, even if you took the meeting date of the 4th of January 2024 as when the retaliation started, that's still 9 months. But I have said in previous videos, I don't accept that, because they weren't retaliating. They turned up for a meeting and were screamed at. That's what Wayfarer are alleging. She always intended to have that meeting as per her 17-point agreement that was dated November. And she controlled the date. She was the one that kept delaying. So I've never accepted that the cutoff from the last act was January 2024. I've never considered that at all. Wayfarer is saying, well, whether it's, the actual time of the sexual harassment in May 2023 or the meeting in the penthouse on January 4th, 2024, there were still many, many months, nearly a year at best, 15 months at the worst. So there is no temporal proximity. And again, there's no evidence she can find that would change that argument. And then finally, the privileges arguments, which makes up the rest of their motion for pleadings on motion for judgment on the pleadings, they also cannot be overcome by evidence. Privilege is privilege. It either applies or it doesn't. Apparently, in response to the question, I don't know what the question was because the audio was actually off for that, but they did recap. It sounds like in response to a question which may have been, why should I deny this motion for judgment on the pleadings, Lively's response was, we have enough to do. Wayfarer's response to that argument is a lot nicer than what I would have said, but what they said was, that's not a legal response, and when she moved to dismiss our claims, we had enough to do too, but we still did it. Judge Lyman did agree that the motion for judgment on the pleadings was not untimely. He asked, why should I move the date for summary judgment? Fritz said, the normal practice is 2 weeks after discovery closes. Lyman asked Fritz, what experts will you need? Fritz said, bots, PR, Lively's damages, and any others will depend on what experts Lively has. Lively was asked what experts she would need. Her attorney said damages, HR, digital, reputational harm, and causation. Lyman then moved to the request for admission. Fritz argued that the deadline had passed. Lively had shown no good cause for an extension. He did compromise, and he said he was happy for the request for admissions, like for an extension to be given, but suggested a limited use to document authenticity only. Lyman then asked, why shouldn't I set the date for motion for judgment on pleadings to coincide with summary judgment? And Fritz said it will be a duplication of arguments. I didn't hear Lively's response to that, unfortunately. Fritz then said there's no guarantee anyone would file a summary judgment. This seemed to upset Lyman, actually. He got quite irate and told Fritz to take back those words. I have no doubt you will file for summary judgment. Fritz didn't take back the words, but he responded with, I was merely saying that it wasn't a given that anyone would file for summary judgment, which is fair. It's optional, so he's not wrong. However, I very much believe that everyone is intending to file for summary judgment. Then the judge made some orders. With regard to the request for admissions, the extension was granted for Wayfarer, Lively, and Jones Works, but the judge accepted Wayfarer's suggestion that it is limited to document authenticity only. The extension on the summary judgment was denied, so the date is still November 5th. Judge Lyman did say, though, that if the parties agreed amongst themselves that that the November 12th date was necessary, then they could file a joint request, and he would consider it, but none of the parties should assume he will grant it. Lively's motion for judgment on the pleadings, her response, So he denied her extension to respond. He denied her request that Judge Lyman deny the motion for untimeliness. Then he denied her an extension to respond. There is a bit of confusion because myself, Lauren, and Cassie, we all heard November 19th as the date, but we think it's supposed to be October 19th because November 19th is far too far away. It's even past the summary judgment deadline. So that makes no sense. It sounds like it was just a mistake by the judge. But we'll have to see what the written order says, or what the transcripts, what the written order says, really. Jed Wallace's lawyer, Chip Babcock, there was a bit of back and forth. Very pleasant, actually. It was really nice. He asked the same questions. So Babcock obviously started with why they, the fact that the claims against them have already been dismissed once, that Lively has refiled. Judge Lyman did say he will be ruling on that, soon. He won't leave it up in the air for long. Lyman asked Babcock what experts he would be seeking to have. Babcock responded with currently digital media and maybe damages / causation. But right now he hasn't given any further thought to it. Lyman asked if he would be needing experts for summary judgment. Babcock said no. Then Lively's attorney said that in Texas, Wallace has sued Lively, not the other way around. So experts would still be required, which is fair. That's true. But as Babcock pointed out, the claim in Texas is defamation, so they may not require the same experts, which is, a spot-on argument. Lyman said that he was going to take that request under advisement. So he did not rule in the hearing, and we will hear what the outcome of that is in due course. So that's it from me for tonight, hopefully, because I've put up loads of videos today. Thank you for coming. I will be doing Stephanie Jones's, the judgment on Stephanie Jones's motion to dismiss from Jen Abel's claim, because that's been ruled on today. It's only Jen Abel's, it is not Wayfarer's so far. But I will be doing that. I'll be doing that tomorrow. Sorry, I'll be doing that tomorrow. Thank you. Have a good night.